Hello everyone, welcome back to day 18 of Polity Daily Drill. Let's begin. First question. Which of the following statements about parliamentary privilege in India is incorrect? A. Parliamentary privileges include freedom of speech in parliament and immunity from legal proceedings for anything said or any vote cast within its chambers. B. MPs are exempt from criminal proceedings during a parliamentary session under parliamentary privilege. Now, this actually is incorrect because the exemption is from civil proceedings, not criminal proceedings. So, B is the right answer because this is the wrong statement. A is correct. Let's look at C. The Indian Constitution does not enumerate all the privileges granted to MPs. This is correct. In fact, it runs more through rules as well as conventions in the House as opposed to the provisions clearly mentioned in the Constitution. So this statement is also correct. And D, breach of privilege is an offence that is determined by the presiding officer of the House and can lead to punishment as decided by the respective House. This is also correct. So B is the only incorrect statement. Moving on to question number 2. Consider the following statements. Remission. It affects both the punishment prescribed for the offence and the guilt of the offender and may completely erase the guilt. Meaning you are absolved of all the guilt, you are free to go. Is that the case with remission or is this the case with pardon? This seems to be a wrong definition actually. Commutation. Temporary suspension of the punishment awarded by a court of law. This is not correct. Why? Because it is reprieve. Commutation simply means you change the nature of the punishment. So primarily you change it from either a death sentence to some kind of jail imprisonment, or you change it from a rigorous imprisonment to a simple imprisonment. So this is also incorrect. And number 3, pardon. Pardon is changing the punishment from one category to another, such as changing of the death sentence to life imprisonment. This is basically commutation. So pardon's definition was mentioned here. This is also wrong. How many pairs given above is or are correctly matched? Only 1, only 2, all 3. None of the pairs are correctly matched. Moving on to question number 3. Statement 1. The governors of states in India are mostly outsiders and do not belong to the state in which they hold the office. This is actually correct. Statement 2. This practice is mentioned in the Constitution and was added to keep the governor free from local politics. Interesting that this part is correct. You see, governors will always be outsiders. We do not appoint local people as governors. Why? So that they are free from local politics and do not cause unnecessary interference in the governance of the state. However, this practice is not mentioned in the Constitution. It is just a convention. Moreover, in 1983, a commission was formed which gave its reports till 1988, which is the Sarkaria Commission on Center-State Relations, chaired by former Supreme Court Judge Justice Ranjit Singh Sarkaria. It was this commission's recommendation as well as convention, a tradition that was followed in our country and not a provision of the Constitution. So statement 1 is correct, but statement 2 is factually incorrect, which means statement 1 is correct, 2 is incorrect, C is the right answer. Moving on to question number 4. With regard to the RPA 1950, consider the following statements. The Act defines corrupt practices which result in the disqualification from voting in elections. So this act defines corrupt practices, yes or no? See, corrupt practices are defined under section 123 of RPA 1951 and not 1950. One is wrong. Second one, according to the Act, the electoral roll for each constituency shall be divided into parts corresponding with the polling areas determined by the Election Commission. Yes, that's true. The polling booth that we have is a small unit of the larger unit called the constituency. Basically, a constituency is divided into small areas, the polling areas. So 2 is correct, 1 is wrong. Which of the statements is or are correct? B. 2 only is correct. And the last question for today. Consider the following statements with reference to tribunals. Number 1. They are not bound by Code of Civil Procedure. This is actually correct. Tribunals are free from the procedural shackles of these rules and regulations. Hence, they provide supposedly quick, fast justice. So 1 is correct. Unlike high courts, says the second statement, they do not have power to punish for their contempt. Now, this is wrong. Tribunals like CAT, they do have power to punish for contempt. So 2 is incorrect. And the third one, in India, the National Tribunals Commission takes care of the administrative and the infrastructural needs of the tribunals. Now, interestingly, there is no such body as a National Tribunals Commission. In fact, way back in the 1990s, 1997 to be exact, there was a very popular judgment, L. Chandrakumar case. It was this judgment in which Supreme Court said that the awards of tribunals should be appealed in the high courts first and then should you come to the Supreme Court. So it basically restored the appellate jurisdiction of the high courts. So it was in this particular judgment that this idea came up for the first time, that why don't we have something called a National Tribunals Commission. So it's not a body as of now, just an idea floating around. So 3 is wrong. How many statements given above are correct? Right answer is A. Only 1 statement is correct. This brings us to an end of our discussion for today. That is it for this video. We'll meet tomorrow. Till then, that's all for me, guys. Jai Hind.